Hello again, and welcome to Video 5, the details of Case Study 3 about South Africa. I'm Tanya Wyatt, a professor of criminology at Northumbria University in Newcastle, in the northeast of England, hosting a series of videos on the results of this project funded by the Arts and Humanities Research Council for World Wildlife Day this year, Sustaining All Life. As I've done for the other two case studies, Canada and Indonesia, I will start with explaining why South Africa and then give the specific background and legislation that are relevant, including CITES trade trends. I'll then share the findings from some of the literature and the interviews that I conducted with experts around the world. During my Arts and Humanities Research Council Leadership Fellowship, I conducted a Delphi iterative survey, and participants in the first round of the survey named South Africa as doing well in regards to CITES implementation and compliance, particularly with regards to enforcement. South Africa is both an importer and exporter of CITES listed wildlife. The exports exceed the imports, and the largest number by record are mammals, which you can see there in the burnt orange in the center, taking up the largest portion of the column, followed by birds, plants, and reptiles. As I said, South Africa is also an importer, but imports are about half as many as exports and consist mostly of plants in the purple at the top of the bar and reptiles in the red just below it. South Africa joined CITES from the very beginning, but did not fully implement it until 2010 with the specific regulations that have again been amended in 2014. There are other relevant pieces of legislation, though, the Biodiversity Act from 2004 and the Threatened or Protected Species Act, referred to by its acronym TOPS. South Africa, like Indonesia and Canada, is also a Category 1 country. It prohibits to carry out restricted activity, which is anything involving threatened or protected species without a permit. I mentioned the Threatened or Protected Species, the TOPS regulations, which place stricter controls on hunting and other activities causing harm to these lists of threatened or protected species. There are the same MA and EA, so the management and enforcement authorities are the same, though they're different people listed on their website, and then the scientific authority is a separate organization. There are standard CITES permits, but my understanding is they're decentralized to the provincial level, or at least have been in the past. Penalties range from 5 to 10 million South African rand, which is approximately or over 800,000 US dollars, and you can be imprisoned for up to 5 years, possibly even to 10 years. So in this structure, there's the national level, and then the 9 provisional legislative provisions that govern the conservation and are brought into alignment by those 2010 CITES regulations that were on the previous slide. Restricted activities are hunting, catching, capturing, or killing any living specimen of any such species by any means or method or device. It's also prohibited to gather, collect, or pluck any specimen of any of these protected species. Picking parts of, or cutting, chopping off, uprooting, damaging, or destroying any such species is also not allowed. Importing or exporting any such species into or out of South Africa without the proper permits and permissions is not allowed. Having in possession or exercising physical control of any such species is also prohibited, and the list goes on into also prohibiting growing or breeding, causing to multiply, conveying or moving, selling or otherwise trading, buying, receiving. These are all activities that are regulated. Penalties, as I said, they look very strict in terms of the amount of fine and and the amount of imprisonment that you might get. Fisheries are weaker within these sanctions, or on the lower ends of these. There is specific mention of seizing vehicles in the legislation, but other information on confiscation is a bit vague. Where the offense involves a specimen of a listed, threatened, or protected species, or an alien species, or commencing the commercialization phase of bioprospecting without a permit, a fine may be determined, either as set out in the preceding paragraph, or equal to the 3 times the commercial value of the specimen or activity in respect of which the offense was committed, whichever is the greater. And that is a quotation from the actual legislation, obviously highlighting not to be bioprospecting or biopiracy that sometimes gets referred to, really trying to protect wildlife as a natural resource and as almost intellectual property could be stemming from that as well. Again, listing best practice on the left and lessons learned on the right. Public participation is actually ingrained within the way that South Africa approaches CITES. So there will be public consultations before the conference of the parties. Obviously, that sounds quite progressive and useful. Again, it would be interesting to delve into more in practice how much that is actually done. The National CITES Management Authority has a member on the Scientific Authority, and this enforcement focal point also attends the Scientific Authority meetings in order to ensure that all of the members are talking, and that's an interesting approach, probably a very useful and effective approach if they're all ingrained in each other's conversations and discussions, and likely this helps to maintain good relations as well as inform one another of important information that needs to be passed along. The Uniform Implementation Guidelines were created for implementation of TOPS and the CITES in order to ensure that all provinces are approaching wildlife regulation consistently. So a central set of these guidelines is produced, which again is a great practice in terms of creating the consistency across the country. In terms of lessons learned, obviously the guidelines were prompted by something, and it was that need for uniformity across the provinces. The DLA Piper report of 2015 pointed that people could pick and choose which province had the weakest legislation in terms of where they would go for permits or where they would commit violations. So to have the Uniform Implementation Guidelines addresses that problem that they saw with their legislation. There will be one more video, 6 of final thoughts and some more general ideas for future research.